Fuck you, JB Pritzker. Fuck you, fuck Moms Demand Action, and fuck all you other groups that fucked with our Second Amendment rights as Illinois citizens, okay? You have been smacked down in court, and you will continue to get smacked down if you choose to take this all the way to the Supreme Court. What am I talking about? Hey everybody, Joe, We the People Firearms Academy in St. Charles, Illinois. Today is Friday, April 28th. It is not Good Friday, but it is a very good Friday. I had no idea when I woke up this morning today was going to be one of the best days of the year for all of us, not just me. Today is the day that a downstate judge, a judge by the name of Stephen McGlynn, put the smackdown to Pritzker, Raul, and all the other commies that said, you know what, we don't want you guys to have guns because then you're going to be harder to control. So this guy, Stephen McGlynn, he actually did a lot of good for gun owners all across the state and inadvertently across the country. Okay, I'll explain what I mean. So not only did he grant a injunction against the Illinois assault weapons ban and magazine ban that was put forth, or that the Protect Illinois Communities Act that Pritzker signed on January 10th, which made it illegal for us to buy ARs or really any kind of semi-automatic rifle, AR, AK, even Ruger 1022s. You couldn't even buy those. They actually said that a 22 plinking rifle was an assault weapon, right? But this guy wasn't having it. So let me read a little bit of this. I'm going to link the entire thing down in the description. So here we go. On June 23rd, 2022, the United States Supreme Court issued its opinion in New York State Rifle and Pistol Association v. Bruen. Amongst other things, the Bruen Court reaffirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. Less than 2 weeks later, family and friends gathered in Highland Park, Illinois to enjoy one of the mainstay festivities of this nation's Independence Day celebration, a parade. They gathered to salute our country, our liberty, and our freedoms. During the parade, a senseless tragedy occurred involving firearms, and multiple parade goers were wounded and killed. Some months after that, the state of Illinois entered the PICA into law, the Protect Illinois Communities Act. The proponents of PICA cited Highland Park tragedy as an impetus for passing the law. The law placed sweeping restrictions and outright bans on the sale, purchase, manufacture, delivery, importation, and possession of many firearms, magazines, attachments, stocks, and grips. PICA was immediately challenged as unconstitutional, not only by us as citizens, but also the majority. And when I say the majority, I'm talking like over 90% of sheriffs in Illinois refused to abide by this because it was that unconstitutional. By the way, I apologize for the planes going overhead. I kind of live near an airport, and this is just too important for me to keep stopping and starting the video all the time. So apologize in advance. As Americans, we have every reason to celebrate our rights and freedoms, especially on Independence Day. Can the senseless crimes of a relative few be so despicable to justify the infringement of the constitutional rights of law-abiding individuals in hopes that such crimes will then abate or at least not be as horrific? More specifically, can PICA be harmonized with the Second Amendment of the United States Constitution and with Bruen? That is the issue before this court. The simple answer at this stage of the proceedings is likely no. The Supreme Court in Bruen and Heller held that citizens have a constitutional right to own and possess firearms and may use them for self-defense. PICA seems to be written in spite of the clear directives in Bruen and Heller, not in conformity with them. Whether well-intentioned, brilliant, or arrogant, no state may enact a law that denies its citizens rights that the Constitution guarantees them. Even legislation that may enjoy the support of a majority of the citizens must fail if it violates the constitutional rights of fellow citizens. For the reasons fully set out below, the overly broad reach of PICA commands that the injunctive relief requested by the plaintiffs be granted. So what he's saying, that even if the majority support it, those rights guaranteed to us by the Constitution, and let me go off on a little tangent here, but those rights are merely guaranteed by the Constitution. They're not given by the Constitution. They're not given by the government. These are God-given rights. These are the unalienable rights that every single person in this country was born with. All the Constitution does is guarantee those rights, that they can't be taken away from you. Okay? It does not grant you anything. Okay? It does not give you rights. It merely restricts the government from taking them away. Okay, so the judge said that, well, the judge didn't say, in order to survive the first phase, a party seeking a preliminary injunction must satisfy 3 requirements. The movement will suffer irreparable harm in the interim prior to a final resolution. There is no, 2, there is no adequate remedy at law. And 3, the movement has a reasonable likelihood on the success of the merits. Now, this judge, Stephen McGlynn, said that in all three things, they are going to prevail. They are going to prevail. They are suffering irreparable harm. There is no adequate remedy at law, and they have a reasonable likelihood on the success of the merits. So that is why he is granting the injunctive relief. He goes on to say, the court will first address defendant's contention that non-essential accessories are not within the scope of the Second Amendment's plain text. PICA outlaws possession of a semi-automatic pistol with a detachable magazine if it is equipped with any of the following: a threaded barrel, a shroud attached to the barrel, or partially or completely encircles the barrel, a flash suppressor, or arm brace. Now, some of those things you may have heard in other states' assault weapons bans. They've all been crafted together to fit together, so you know, they all appear to be the same, kind of all written to be, you know, appear to be written by the same group of people. Wonder who that could be. Let me think about that for a second, okay? But here's the really cool part about that. He actually brought up arm braces in this. We all love you, Judge McGlynn. We really do. Okay. He brought up arm braces, that we had, you know, arm braces are part of the Second Amendment. Okay, so let me keep reading on this. PICA further outlaws possession of a magazine for a handgun capable of holding more than 15 rounds of ammunition, and of a semi-automatic pistol that has a fixed magazine with the capacity to accept more than 15 rounds. Defendants contend that such items are not necessary to the functioning of a firearm, and thus not arms, and therefore not protected by the Second Amendment. That argument is not persuasive. All right, so he's not buying it. Good for him. He shouldn't. The defendant's own expert defined high-capacity firearms as handheld arms with a capacity greater than 10 rounds, recognizing that Illinois statute allows up to 15 rounds for handguns. Defendant's expert is clearly referencing magazines and incorporating such into his definition of a firearm. The court agrees that magazines are arms and as used in the plain text of the Second Amendment. Plaintiffs are correct that this isn't even a close call. It's not. If defendant's own expert incorporates magazine capacity into his definition of a firearm, given his level of expertise, it would be unreasonable to expect the original public meaning of the plain text to not reflect a similar understanding. To provide one example, consider arm braces for semi-automatic pistols. As noted above, PICA prohibits the use of an arm brace on any semi-automatic pistol with a detachable magazine without any caveat or exemptions. The Department of Justice has also attempted to regulate possession and restriction of arm braces. As reason in the ATF final rule evidences, braces are needed by certain individuals with disabilities to operate a firearm. Thus, arm braces are an integral part of the meaningful exercise of Second Amendment rights for such individuals and can also be considered an arm. So now he's considering pistol braces to be arms as defined under the Second Amendment. Awesome. Love you, Judge Glynn. He's going to talk about a few more things, and he's going to bring up ARs, right? So, however, supposing that defendants need only to show that AR-15s are not in common use, they still fail. Plaintiffs assert that practically all modern rifles, pistols, and shotguns are semi-automatics. Plaintiffs added that recent data showed that more than 24 million AR-15 style rifles are currently owned nationwide. As the Fourth Circuit noted in 2012, the number of AR and AK style weapons manufactured and imported into the United States was more than double the number of Ford F-150 trucks sold, the most commonly sold vehicle in the United States. 24 million firearms dwarfs the 200,000 stun guns, which the Supreme Court found sufficient to meet the common use test. Love this. The judge saw through none of their bullshit. That was the stun gun, or the common use test, the common use test. That was Caetano v. Massachusetts, and that was in 2016. Under the Caetano test, even 1% of the 24 million AR-15 style rifles held by citizens is sufficient to result in a finding that such arms are in common use. However, the court need not rely solely on the current ownership numbers to determine commonality of these arms. The AR-15 style rifles are among the most popular arms produced, accounting for nearly half of all the rifles produced in 2018 and nearly 20% of all firearms of any type sold in 2020. If that doesn't suggest common use, I don't know what does. All right, saving the best part for last, the conclusion. Plaintiffs have satisfied their burden for a preliminary injunction. They have shown irreparable harm with no adequate remedy at law, a reasonable likelihood of success on the merits, that the public interest is in favor of the relief, and the balance of harm weighs in their favor. Therefore, the plaintiffs' motions for preliminary injunction are granted. Defendants are enjoined from enforcing Illinois statutes 720 ILCS 524 19B and C and 720 ILCS 524 110, along with the PICA amend provisions set forth in 735 ILCS 524 1A, including subparagraphs 11, 14, 15, and 16 statewide. So this doesn't just apply to those that took part in DeVore's law cases or DeVore's lawsuits, earlier this year. This applies to everybody in the state. Statewide, during the pendency of this litigation until the court can address the merits. The court recognizes the issues with which it is confronted are highly contentious and provoke strong emotions. Again, the court's ruling today is not a final resolution of the merits of the cases. Nothing in this order prevents the state from confronting firearm-related violence. There is a wide array of civil and criminal laws that permit the commitment and prosecution of those who use or may use firearms to commit crimes. Law enforcement and prosecutors should take their obligations to enforce these laws seriously. Families and the public at large should report concerning behavior. Judges should exercise their prudent judgment in committing individuals that pose a threat to the public and imposing sentences that punish, not just lightly inconvenience, those guilty of firearms-related crimes. So, not only has he laid the smackdown to Pritzker, Kwame Raoul, Moms Demand Action, Brady, and all Giffords, and all the other gun groups that are trying to strip us of our Second Amendment rights, he is throwing the gauntlet down and put the smackdown to prosecutors like Kim Fox, judges in Cook County that would, just let somebody convicted of a firearms-related crime go with a slap on the wrist and allow them to reoffend a couple hours later. So good for you, Judge Glynn, or McGlynn, excuse me. Good for you, Judge McGlynn. You are definitely the kind of judge we need in the state. You are not only upholding our rights, but you are letting the prosecutors that, the Soros-backed prosecutors that would ordinarily let these people back out on the streets within a matter of hours to say, hey, you know, you guys have a right to protect the public, not just those accused of committing these crimes. Do your jobs. Do your jobs, prosecutors. Do your jobs, police. I mean, the police are doing their jobs. You know what I mean? They're doing their jobs. They're solving these crimes. They're getting guns off the street. They're arresting people with them, only to have the prosecutor's office turn around and say, hey, you know what? We're just going to give you a slap on the wrist and go, right? So it's BS. We don't want it in our state. There's nothing more I can say. I am in such a happy mood right now. I really am. Honestly, this is just a wonderful day, right? Friday, April 28th, 2023, day that will live in infamy for a long time. Do I think this is the last of it? No, right? Pritzker is probably going to challenge it because, you know, how dare you, you know, go against my authority. You know, he thinks he's the king, the emperor, dictator at large, whatever you want to call him. All he is a disgustingly fat piece of shit who wants nothing else than to trample all over our rights. I said it at the start of the video. I'm going to say it again. Fuck you, JB Pritzker. Fuck you, Kami Raul. And fuck you to Moms Demand Action, all the people, the part of Brady, Giffords. Fuck all you guys, right? We have a really nice win. We are gonna, oh man, I don't even know what I'm gonna go out and buy right now. I really don't, but it's gonna be good. You know, I've suspended all my purchases. I wasn't part of any of the lawsuits. I am gonna go out, you know, probably buy some magazines. You know, maybe this 2011 that I've had my eye on, you know, competition gun for shooting at competitions. So probably going to do that. A buddy of mine, you know, wants me to get into running the tactical games. So probably going to do that. And yeah, let me know down in the comments your thoughts. Let me know what you're going to go out and buy. Let me know what you're going to go out and have fun with. Hopefully, you know, well, I mean, not this weekend, but hopefully sometime relatively soon, maybe next weekend. Let me know what you're going to be shooting. Sign up for some classes. We got rifle classes going on this spring, summer, fall. We've got advanced concealed carry. We've got tactical classes. These are all classes that are going on outdoors, okay, not stuck in a classroom. If you want stuck in a classroom classes, those are going to be like, you know, pistol 1, concealed carry, anything that I have to be in a classroom to teach you about, right? Rifles, no. Tactical stuff, no. Those are all outdoors. Advanced concealed carry, when we're all, you know, moving and shooting, running and shooting, well, not running and shooting, turning and shooting, you know, all this fun stuff that you're going to be doing as a concealed carry holder. You got to know all this stuff. So head over to the website. Link is right below you, or at the bottom of the screen right now. I'm going to link it down in the description. Hope to see you guys in a class sometime soon. Give me a high five through the screen. Boom, right there. Love all you guys. Until next time, stay safe and have fun on the range.